Hi, I am attorney Michael Eline, and I'm again here with Louis Holtzberg, and he's in Miami, Florida, and I am in Los Angeles, California. And we're going to talk a little bit about today about a topic that Louis is intimately familiar with, and it has to do with this recent cruise ship landmark ruling about COVID cases and the cruise lines having to pay passengers for exposure, et cetera, et cetera. And I wanted to remind everybody first that what Louis and I are doing here today, it's a free service. It's separate and apart from our work at our prospective law firms. We're doing this because a lot of our clients and us, people that we know have been on cruises, they've suffered or they've had problems on fisher ships, fishing vessels. And we, hear all these stories all the time. And we wanted to share some of these unique things with you so you don't have to suffer if you do decide to go on a cruise or you do decide to go fishing or get a job in the commercial fishing business. So, Louis, go ahead and tell us a little bit about this case and share anything on the screen you think is important for us.
So, Mike, thank you again for having me on the show. And what I do want to do first is I want to go back in time. Okay. I'm sure we all remember February, March of 2020 when it was a different world then. And we all started first hearing whispers of this thing called COVID. Many of us will remember a very specific cruise ship. It was called the Diamond Princess. It was anchored off the coast of Japan, and it involved a group of passengers who were not being allowed back into Japan to conclude their cruise. And they ended up being quarantined on the vessel for several weeks before the Japanese government basically figured out what to do with these people, how to repatriate them to their respective countries, and how to keep the citizens of Japan on the mainland safe. Well, simultaneous to what was going on in Japan, another princess vessel was affected in a similar way. This involved what was called or is still called the Ruby Princess. So the Ruby Princess was off the coast of Australia, and at the time, there was also rumors of COVID on that vessel. Many of the passengers ended up getting COVID, and in a similar way, the Australian government had to figure out how to deal with the passengers still on the vessel, many of which were repatriated home, some of which to the United States. Now, fast forward to 2023, as of, I believe, yesterday in Australia, there was a ruling that found in favor of the passengers who were infected with COVID and were able to recover their economic damages. Now, an important teaching point here is that in the US, we are entitled to both economic and non-economic damages. So when you see a jury verdict form, typically the jury has to decide whether there are economic damages and non-economic damages. The economics would include medical bills, out-of-pocket expenses. The non-economic damages are things like you've heard of maybe pain and suffering or mental anguish, emotional distress. These types of damages tend to be the bigger drivers on the large jury verdicts you see here in the US. And it seems to be that in Australia, they have a similar system. We are both based on British common law. In that case, while Carnival, the parent company for Princess Cruises, was found liable for economic damages, no other damages were awarded to that passenger. So in total, they recovered approximately $4,000. I'm uncertain at this time whether that's Australian dollars or US dollars, but regardless, this is not as big of a win as it might appear on its face.
It says here it's $2,826 US.
Okay, so the 4,000 was Australian dollars. Thank you, Michael.
Yep.
And the ultimate outcome, though, is the judge ruled that Princess and Carnival, the parent corporation, were negligent for simply allowing the cruise to sail after it was known, specifically the Diamond Princess, which happened in February of 2020. It was known by Princess that COVID was on its ships and that COVID was a risk not only to the passengers on board the vessel and crew, but also was a risk to the entire country, in this case, Australia. And I believe the court made the right ruling. I believe that it was negligent by Carnival not to cancel these sailings. And I believe ultimately that's why you see this finding by the court. Now, interestingly enough, they did not rule that they were entitled to any non-economic damages. Why is this important? Well, on these vessels, many passengers and crew were on board, quarantined, living in a situation that none of us would want to be in. If you've never been on a cruise ship, imagine a very small 10 foot by 10 foot, 12 foot by 12 foot room in which you are quarantined to, being served a very specific diet. They could not interact in the kitchens in the way they normally would. These were very simplistic meals for days on end while you were stranded on board a vessel. You could imagine the mental toll and anguish that this was putting these passengers through, many of which I'm assuming sought mental health counseling after the fact. Those passengers who suffered mental anguish without any treatment and without any economic damages, meaning they went to a psychiatrist or psychologist and they obtained medication or any form of counseling, those passengers under this ruling would be entitled to nothing, because even though that they were highly distraught, and they may still be suffering to this day for post-traumatic stress disorder or general anxiety disorder or other related symptoms, under this ruling, they would be entitled to absolutely nothing. And it's an important distinction that we need to draw. Many of the articles that you'll find on this are all from financial publications. Why is this important? Well, the impact this morning was one in the stock market. And the question was whether Carnival's stock would be highly impacted. And I am not a financial professional, but in my opinion, given the small amount of damages, I do not know that this would have such a significant impact. However, the ruling itself is interesting because as we sit here today, there are still cases pending in the United States in the Central District of California, which is where the principal place of business of Princess Cruise Lines is. Certain US passengers on board these Australian vessels are pursuing their damages claims. This ruling will offer as persuasive evidence to the courts and potentially be admissible to the jury in those subsequent trials. And it's important to note this judge's ruling could impact US cases.
So one thing that I do know is that the cases in California against Princess should be handled under the California common law principles. And so I'm trying to understand why non-economic damages are not being awarded for laymen, so that people on the outside can get a better understanding. Like, why is it that pain and suffering isn't being awarded? Is it because of a treaty? Is it because of the passage contract? What's going on?
So it's a good question, Michael. And I saw this occur here in Miami. So the principal place of business for Carnival, the general brand, as well as Norwegian Cruise Lines and Royal Caribbean Cruise Line, are all here in Miami, Florida. And if you are pursuing a claim against those cruise lines, you have to pursue your case in the Southern District of Florida in the Miami Federal Courthouse. In those cases, there was a ruling that came from a Princess case that became persuasive law to the cases in Miami. So what's going on in these COVID cases is this is a novel infection and continues to be a novel infection. And the courts do not have a lot of guidance by prior rulings, for example, in asbestos cases, that they can look to and say, this is how this was decided previously. So instead, they have to be able to they have to be able to point at these other courts and these other rulings to find some persuasive or dispositive information and case law, because without that, there really is no guidance.
Understood. And then, so just for some of you law students who may be confused, it is true that normally we don't use foreign rulings, but because it's admiralty maritime law, there's sometimes treaties come into play, and case law that normally we may not use would be used in our federal system when it comes to interpreting things that happen on the high seas. Is that a fair statement?
Yes, when it comes to general maritime law, I think the word is amalgam. They say that the basis of maritime law is an amalgam of all common law and technically even some civil law, because the roots of our legal system really go back to maritime law. If you think back to the foundation of the United States, the first laws that were being implicated by the revolutionaries were taxes. Well, those taxes were on imports, and those imports were coming on vessels. So if you think back to the Boston Tea Party, what they were really upset about was that they were taxing the price of tea being imported. and they were being imported on vessels, not just British vessels, but all vessels. And those traditions stand to this day, and those rulings stand to this day. Fast forward to the present, in terms of COVID, they did not have decisions like that to look at. So instead, they're looking at other common law countries, in this instance, Australia, to make rulings, and this could have an impact on the US system.
Got it. So we are out of time. Put your questions in the comments and we'll answer them. If you have any other things that you want to know about, always ask, like, and subscribe. Take a look at the description so you can get a hold of Lewis, and Adam is a friend on Twitter and whatnot. Thanks